Now, we have seen 245. We have seen 245 already narrated. Then we have 246. 245, once again I will repeat. 245 gives power to the Parliament to enact law throughout the territory of India or any part of it. 245.2 says, a law made by the Parliament shall be deemed to be valid on the ground it is extrajudicial in operation. So it means that it should not be invalidated on the ground it transgresses the territory. Even if it transgresses the territory, it is deemed to be a valid law. This has to be read along with the three acts in what is stated in the preamble of the act also. So if you take that into consideration, you can feel that the law enacted by the Parliament can transgress the boundary of the India and can have its effect and operation even beyond the territory of India also. This is 245.2. Then 246.1 is, notwithstanding anything in the class 2 and class 3. Class 1 here deals with the union list. Class 2 deals with the concurrent list, which is the list number 3 in the 7th schedule. Class number 3 is the state list. Class number 3 is a state. Here in 246 it is dealt with, state list is dealt with, but actually if you take the 7th schedule, the list number is 2. Vice versa it's been given, but don't get confused. But class number 1 pertained to 240. We will now deal with only with the 246 alone. Don't go to that to 7th schedule. 241, class 1 deals with the list number, union list. Union list is notwithstanding anything said in the class number 2 and 3 of the 246. So therefore, the power that's been given to the Parliament will prevail over, will have a supremacy over any act or any law that's been enacted under the concurrent list, concurrent power or state power. That's what is a notwithstanding anything in the class 2 or class 3 says. Here then comes to 246, please come to 246 class 2. 246 class 2, notwithstanding anything said in the state list. What is it start? How it starts? It starts notwithstanding anything stated in the class 3. Class 3 is now subordinated. What is class 3? State list. State list is subordinated. Notwithstanding anything in the class 3, Parliament will have a power to make laws in the concurrent list. Then continue here. Subject to class 1. Subject to class 1 means I am subordinated. Class 1 is superior. Concurrent list power under the Parliament is subordinated. I am subordinate to whatever is stated in the concurrent list will not prevail, but only whatever is stated in the Parliament list, that is list number 1, it will prevail over, even if when you compare it with the Parliament power with the concurrent list. That's what is the meaning here. I hope this is a very little tricklish area to understand. See, first one is, I told you first one. There is the supremacy, absolute supremacy for class 1. Class 2, subject to anything, notwithstanding anything in the class 3. That is, you are subordinating the state power and subject to the class 1. Subject to the class 1 means union list. The legislature of the state will have a power to make laws with respect to the matter enumerated in the concurrent list 3. You read it 2 or 3 times, you will have a clarity over it. So, if any doubt, you can ask sir also. Then third one is subject to the class 1 and class 2. The state will have powers with respect to the state list. It means that state list is subordinated and will not have a primacy over the list number 1 or the concurrent list. I am subordinated. Whatever is stated, if it is going to be void, to the extent of the voidness, to the extent of the repugnancy, I will be void. Or the state list. State list will be void to the extent of repugnancy. This is stated in the class 3 of the 246. I will once again read it. Subject to the class 1 and 2, that is union list, concurrent list, the legislature of the state has exclusive power to make laws for such state or any part thereof with respect to the any matter enumerated in the list number 2 state list in the 7th schedule of the Constitution of India. This is what is the, you have to understand. See, simply stating, there are about 246, don't confine to 246, and also you come out of the 246, how many powers are there? See, we can say Parliament will have exclusive power number 1, exclusive power over the list number 1, concurrent power over the list number 3. Concurrent list is there, concurrent power over the list number 3. Similarly these two power, exclusive power over the list number 1, concurrent power over the list number 3. Similarly, state also will have concurrent power over the list number 3, and state also will have exclusive power over the list number 2. There are 4 powers. Then apart from that, what are the powers available to the Parliament and state? Apart from that, no power is available to the state, but Parliament is getting 2 more powers. The third power is power on the basis of the residuary entries. The entries are the subject matters which not been enumerated in any of the list. The Parliament will have a power under Article 248, read with the entry number 97 of the Constitution of India. 248 read with entry number 97 of the list number 1. So this is an extraordinary power that's been given to the Parliament. That is an residuary power. Whatever has not been stated. See, I said about 200 acres of land. Some more lands are there spreading over somewhere else, which have not been identified. No one knows, neither state knows nor Parliament knows. In those lands which have not been identified, not been enumerated, not brought us the subject matter in the any of the list, in those lands, in those subject matter, the Parliament will have power. The residuary power of the Parliament under 248 of the Article 248, I read with 97 of the entry number 97 of the list number 1. This is one another power along with the 4 powers that's available. So apart from that, one more power which is available to the Parliament, which is so important, which is the primary answer for this question. What are the issues that's been raised in Pragya Singh's case? This would be the primary answer. No other answer is required for in my simple understanding, for my simple knowledge. No other answer is required except this. Here it says, I'll give you 3 articles. Three articles I'll give you, where the state will have, the Parliament will have power to enact law on any subject that's been enumerated in the state list number 2. That is the article number 246 clause 4. 246 clause 4, the Parliament can encroach into the state list, state power. 246 4, 249 in the national interest. Then 250 while the proclamation is in operation. That 250. So these 3 articles, which if you bear it in your mind, 249 is more important, where in case of any national interest is involved, the Parliament has absolute power to get into that. Only precondition is that the Rajya Sabha should pass a resolution. That's it. The Rajya Sabha, if passes a resolution, the situation has arisen now to pass an act with respect to the sum of the matters which are stipulated and entered into the list number 2, which has been given to the power that's been given to the state list. The Parliament is empowered to enact an act under the name of the national interest. Then the 250, I need not have to say, that is an emergency. During the emergency, the Parliament, they can suspend the fundamental rights, they can also take out all the powers that's been vested with the state, and they can enact law. This is what is the 3 important articles. You have to bear it in your mind as far as. So therefore, in my knowledge or in my small opinion, there are 6 powers available to the Parliament. I'll repeat it. The first one is the exclusive power under the list number 1, concurrent power under the list number 3, and the Parliament power to enact any law under the state list while in the name of national interest, in the national interest. And fourth one is that what did I say, that in fourth one is 246.4. 246.4. If you see that 246.4, I'll read. Parliament has power to make law with respect to any matter or part of the territory of India, for whole of India or part of the territory. I'm sorry. Parliament has power to make law with respect to any matter for part of the territory of India not included in the list, not included in the state, which is not a part of this area. Suppose you assume that Kachativu is with Tamil Nadu. It is not a part of Tamil Nadu. Assume that it is not a part of Tamil Nadu. Then the Parliament has power to make a law which is not for a portion of the land which is not a part of any state, in respect of any other matters enumerated in the state list. So, if the part is not connected to any state, the Parliament has absolute power, exclusive power, here also exclusive power to enact law with respect to any subject matter that is enumerated in the state list. Here also the state list comes into play, but state doesn't have power. The power is with the Parliament. What is the condition? This part is not part of any state. Condition is this part is not part of any state. It's an independent state. Maybe it is not also included in the union territory, but it's like an independent island, like something else. If you take the what do you call that, a place called Toothukudi is there, Tuticorin. Very close to the Tuticorin, if you cross Tuticorin airport, there will be about 6 or 7 islands will be there. Like I know that one Tivu is there, one is Mullai Tivu, 2 Tivus I know that I visited. No man's land. It's like a bare land with about 15-20 acres, fully surrounded by water, and there will be a lot of thorns and bushes will be there. You can go and have a pleasure time. I went along with the police officers, naval officers and police officers were there, and I was taken by them. This is a no man's territory. It is not part of Tamil Nadu. So, with respect to this area, the Parliament has absolute power to enact law with respect to the not with respect to the Parliament list, with respect to the state list. This is a power that's been given under 246.4. So 246.4, it's a different power given to the Parliament with respect to the state subjects. That is list number 2. So this is 1. Then we will come to 249. Power of the Parliament to legislate with respect to the matter in the state list in the national interest. Notwithstanding, opening class, please see the non-obstanding class here. Notwithstanding anything in the foregoing provisions of the chapter, if the Council of the States Rajya Sabha has declared by resolution supported by more than 2/3 of the members of the present and voting that it is necessary and expedient in the national interest that Parliament should make law with respect to any matter enumerated in the state list specified in the resolution, it shall be lawful for the Parliament to make law for whole or any part of the territory of India with respect to which respect to that matter while the resolution was remaining in force. That resolution remaining in force was 6 months or 2 years, something like that. It's been defined. But yet, that Parliament will have a power. Parliament has a power. If at all a resolution is going to be passed by the Rajya Sabha, then the Parliament can take the state lists in its hand and enact laws for the purpose of in the protection of the national interest. This is the 249, Article 249 says. Before that, 248, very simple article I said. This one another article you have to keep in mind. Next we will complete that extra parliamental jurisdiction over, apart from that exclusive power and concurrent power. Then you come to 250. Then we will go back to 248. Okay. 250, Parliament power to legislate with respect to any other matter in the state list if a proclamation of emergency is in operation. Suppose because of the Taj Hotel and because of the other blast in the other railway station, suppose the central government has declared, no, we have to declare emergency there in the Maharashtra, we will declare it. Emergency has been declared. In that instance, the power that's been vested with the state legislation will pass on to the Parliament. Parliament can pass any law pertaining to any subject which has been enumerated in the state list number 2 and to make laws in case the emergency is in operation. That's what the 250 says. 250, I will read it. Notwithstanding anything in the chapter, Parliament shall, while proclaiming the emergencies in operation have power to make laws for the whole or any part of the territory of the India, or with respect to the any matter enumerated in the state list. So this is one of the extra powers beyond 246. Therefore, I say there were 6 powers that been available to the Parliament. One is exclusive power with respect to the state list. Second one is the concurrent power which is with respect to the list number 3. Third one is the 246 2 power if this part of the India is not a part of any of the state. With respect to that, state power could be invoked or enforced. Fourth one is in the national interest. The other one is that in case of any national emergency. If you take all these things, it will go to 7 or 6. I think it will go to 7, I think. Well, whatever it is. These are the extra powers that's been given to the Parliament. This is how this. Then the residuary power comes. The residuary power, if you take 248, the 248 says the Parliament has exclusive power. Here also the exclusive power comes. The residuary power is an exclusive power of the Parliament. Exclusive power to make law with respect to any other matter not enumerated in the concurrent list or the state list. If the matter has not been enumerated in the concurrent list or state list, that matter will be considered as an extra matter, extra residuary matter, and this matter, with respect to this matter, the Parliament will have full powers over it and they can enact law. This 248 should be read along with the entry number 97 of the list number 1. Entry number 97 says, any other matter not enumerated in the list number 2 and list number 3, including any tax not mentioned in either of those lists, the Parliament will have power. This is coming under the list number 1. So 248 has to be read along with the 97 of the 7th schedule of the Constitution of India. So this is the one of the power that is available to the Parliament. So now we will come directly to the point. What is power directly which is available for the purpose of enacting these laws, for the purpose of passing the test before the court, proving the competency. I have the competency to enact this law. I have the competency to save the country. I have the competency, I have this duty to save the country. Therefore, I enacted the law. So this is what now we are going to, at last we are going to see that. Now, you please see, I think almost I have completed all these things. You see one another parallel, before going into the list, before going into the exact, the core of that issue, one another direction, you please see the article 365 of the Constitution of India, please. If you take the 365 of the Constitution of India, it's almost akin to the 356, where the report is generated by the governor. Here there is no report is generated by the governor. Simply a direction can be given to the state government. And if the direction has not been complied with, not been enforced, then the president can directly involve and he can make a report saying that the government cannot be carried out in accordance with the Constitution of India. Hold. It is lawful for the president. Yeah, I'll read that entire sentence of this 365. Please bear it in your mind. Where any state has failed to comply with or give effect to any directions given by the central government in exercise of its executive power of the union under any provisions of the Constitution, it shall be lawful for the president to hold that a situation has arisen in which the government of the state cannot be carried out on accordance with the Constitution of India, on accordance with the provisions of the Constitution. So, for the purpose of enforcing any subject matter in the list number 1, the central government can give any direction to the state government for enforcing it. Suppose if the state government does not comply with that, and if does not give effect to any direction which had been given in exercise of the executive power of the union, it shall be lawful for the president to hold that the situation has arisen that the government of the state cannot be carried out in accordance with the Constitution of India, in consequence of which also 356 could be invoked. In consequence of which also 356 could be invoked in the state. So this is one another extraordinary power that's been given to the central government. So you have to bear it in your mind all this. Now we will go to the list. This I have already shown that you can now recollect. In the preamble I said that the act has been enacted for the purpose of saving the sovereignty, protection, integrity, security, and for any law which has been made for the purpose of enforcing any decisions that's been taken during the any international convention, agreement and treaties. This is what is the core and crux of this preamble. It may be taken as in all the cases. It may be of NIA, it may be of PMLA, or it may be of narcotic drugs, for which to prove the competency, to prove the parliamentary competency, I will narrate some of the entries here. Please understand, please bear with me for some time. First, entry number 1 is defense of India and every part thereof in the case of war. It is a duty of the Union to make law for defending the country during the course of the war, and including the preparation of the defense and all such acts which may be conducive at the time of the war. Number 1. Number 2, naval, military and air forces, that we can leave it. This when the foreign force enters, when an terrorism force terrorist enters and attacks the territory of India, it's almost a war against India. It's threatening the peace of the country. So it could be taken as a war. So the defense of India, the responsibility of defense of India is with the number 1. It is with the Union of India. Number 2, naval, military and all works. Forces, they are under their control, and the works pertaining to this defense also under their control. I am not going into that. 4, if you take the 4, entry number 4, naval, military and air force works. 5, arms, firearms, ammunitions and explosive substances. Arms, firearms, ammunitions and explosives. If you are using the explosive substances for blasting a place, they can make any law for the purpose. This explosive substance will be used for the purpose of cross-border terrorism. There could be a lot of money which could be transacted. If you do all these things, I will pay you 30 crores or 50 crores to your family, and the money will be given in Dubai or Singapore. Anything could be said. With respect to the money, we will have to investigate. With respect to the crime also, we will have to investigate. So here it's arms, ammunitions and explosives. Next one is atomic energy, which is also internationally it could be smuggled, trafficked. Then comes, you see, Central Bureau of Intelligence and Investigation, entry number 8. See, entry number 8, though not specifically says it's a police force could be created, it says Central Bureau of Intelligence. That is, they can make an intelligence and make an intelligence prior to what is going to happen, and also investigation subsequent to the occurrence. So this is almost akin to the police force, which is the entry number 2 of the list number 2. Then comes the foreign affairs, entry number 10. Entry number 11 is diplomatic consulate and representation. 12 is United Nations organizations. 13 and 14 are very important here. 13 and 14, participation in the International Conferences Association and other bodies and implementing the decision thereof. So once you are participating in the international conference, and if you want to implement the decisions which have been taken there, and for which if you enact a law, and that law is a valid law, I have the legislative competence. And also the 14, you see, similar to that 14. Here it is a participation in the international conference. Here it is entering into a treaty and agreement with the foreign countries and implementing the treaties and agreements, conventions with the foreign countries. Here it is implementing. Here is 13 is also implementing. 14 also implementing. Here it is a participation in the international conference. Here entering into treaties itself. I am a signatory of the treaty. I am a signatory of the agreement with the foreign countries. For this purpose, I can make laws for the purpose of protecting the integrity of this nation as well as that nation. Reason being that I should not spoil my relationship with other nation, which is very clearly stipulated in the object and reasons of the NIA. If any offence is enacted which is going to destroy the relation with the foreign country, that offence is covered under the NIA. So 13 and 14 is more relevant for the purpose of NIA. Then comes a war and peace and foreign jurisdiction, extradition and permitting a person as a citizen or not, so and so. This is the area which gives the power to the parliament to enact law, to implement the any foreign agreement, any conventions, any treaties that's been entered either with the UNO or its agencies or with any foreign nation or with the small international bodies like SAARC and other international bodies. So this is the important thing. Then comes the, what is the prime subject matter here is that entry number 2 of the state list. Entry number 2 of the state list is the police. Directly it says about the police, including the railway police, village police, subject to the provisions of 2A. 2A, central government is having a power to give a civil force for the purpose of aiding the civil power. A state, to aid of the civil power, they can deploy some armed forces to the state for the aid of the civil power. That's totally different as a subject. We need not have to go into that. And it's 2 is the point where it's the exclusive power of the state. So therefore the contention was raised here. This is a police force. NIA is a police force. It's a subject of the state, and therefore the parliament will not have power to enact law pertaining to the police, since it is the exclusive power of the police. That's what the answer has been given. It may not be not required. It not required. It needs to be specifically stated or designated as a police officer. Even if the police officer is given, that police officer's powers could be given under these various entries in the list number 2, which I have stated now in 13 and 14, and also under 8 of the 8 of the list number 1, which is the Central Bureau of Investigation and Central Bureau of Intelligence. So this is what the answer that's been given. The one another contention that's been raised is, interestingly, if you see that concurrent list, the criminal law, entry number 1 says criminal law. Entry number 2 says the criminal procedure code. Entry number 1 will specify the offence. What is criminal law? It's a criminal, this including the Indian penal offences which are stated in the Indian penal code. So the Indian penal code, whatever the offences which are stipulated in the Indian penal code, mentioned in this Indian penal code, are coming under the concurrent list, but investigation is given to the state police under entry number 2 of the state list. So this is what the contention that's been raised. Though you create a new offence by means of a new law, the investigation is always with the police under entry number 2 of the state list. That contention also was overruled. There is a triangular force here. The offence is created under entry number 1 of the concurrent list, and investigation is done by the police force, that is entry number 2 of the state list. And what is the procedure that is adopted here? One is an offence which is being investigated. One is a police force which is working on it for investigation. Third one is what is the procedure adopted. The procedure falls under the entry number 2 of the concurrent list. So for these two things, for this offence that's been created and for the procedure that's been created for the purpose of investigating the offence, both fall under the concurrent list. Only the force is with the state list. So the contention that was raised, that even you may have a own procedure, even you may have your own offences that's been created, you have to entrust the investigation to the police that's been created under entry number 2 of the state list. That is also one of the contention that's been raised. The answer that was given is no, not necessarily. This is how the judgment ends. I hope that I have made myself clear with respect to this the topic that's been given. Thank you for this opportunity. Thank you, sir. Thank you, Veerappan, sir. Thank you so much. There are so many terms I could not convert it into Tamil, so therefore I continuously blasted my discourse in my own language. Kindly excuse me for that. I will explain you in person, sir. Thank you so much for your patient hearing.